Hello, I'm attorney David Abrams, and I'm here today with your Consumer Law Minute, except today's Consumer Law Minute isn't going to last a minute, and it's not going to be about consumer law. Today, I want to talk to you about the recent leaked Supreme Court decision in the case of Dobbs versus Jackson Women's Health Organization. Dobbs is unquestionably going to be the biggest decision from the Supreme Court this year and perhaps in the last decade. The leaked draft opinion is revolutionary. It greatly alters the law in the United States, not just for abortion, but for other things as well. And I'm going to talk to you about that. First of all, to even get this draft opinion is such an abnormal thing. This just doesn't happen in law. And this is not a full final decision, right? We don't have any of the concurring opinions. We don't have any of the dissents, which I'm sure are coming from the more liberal members of the court. But what we do know is that the Supreme Court is about to radically alter the playing field when it comes to abortion and when it comes to the private lives of Americans. This is just earth-shattering. It is a radical departure from what we've had. And what this case is about is really overruling two prior cases, Roe and Casey. And these are both cases which upheld the idea that women have a constitutional right to abortion during their pregnancies. And this is a decision that was written by Justice Alito. The draft opinion runs about 98 pages. It's a long, winding, kind of rambling decision. This is not a concisely written opinion. Now, the final product may be much more concise, right? This is a draft, and this is just a first draft of the opinion. But if this draft opinion is anything like what the court is ultimately going to issue, it is a total game changer. So, let's talk about the Mississippi law and what was the issue, right? The Mississippi law prohibited abortion after 15 weeks, which is a departure from the standard of viability, right? Which is much later. We're getting into really the third trimester before the state has what was considered a compelling interest, such that they could regulate abortion and limit it, or even have an interest in a woman's fetus. And really, as the law currently stands, because the law hasn't changed yet, right? Women have a right of privacy to be left alone during their pregnancies, right? To not have the state intrude into their decision about their reproductive lives. And this was an issue in a case that I did about 10 or 12 years ago called Burton versus the state of Florida, in which we secured the right for women in Florida to make their healthcare decisions during their pregnancy. And these, even though I'm a consumer lawyer, these types of cases really interest me because I'm also a registered nurse. So the availability of healthcare and the ability of women to come into healthcare and trust their doctors and get their care that they need is really important to me. So let's talk about what is Alito's take on this? And the first and foremost thing is he's unequivocally overruling both Roe and Casey. And he says that there is no constitutional right to abortion. And what he does is really very much Federalist Society thinking, right? And that is, he doesn't look at the justice of it. He looks at this issue and analyzes it as if he were living in the 17th century. He does not look at this from a modern standpoint. This is a very old-fashioned approach. Right? This is a very what we call legal positivism approach. He's not concerned about outcomes, and he actually says that in the opinion. He's not, the outcome, the political ramifications of this decision, what it does to the lives of women are not the concerns of Alito, according to this draft opinion. So, and what's interesting about this case is there's not really a lot of legal argument in it. There are some sections where he talks about the equal protection and why that doesn't apply. He says that the prohibition of abortion is not does not constitute an invidious, discriminatory animus towards women. So he doesn't feel as if it's harmful to women. He really doesn't deal a lot with, but rejects very quickly the idea of that there is a privacy right that emanates from the 14th Amendment in the Constitution. And that's really a very important right for a lot of other freedoms that Americans enjoy, the freedom to birth control, the freedom to parent your children the way you'd like, the freedom to send your children to religion schools, all those kind of things emanate from this privacy right that the courts have long held is, while it's not explicitly written in the Constitution, it is definitely implied, and the courts have upheld it many times. And they've said that a privacy right is subject to a very strict judicial review that we call strict scrutiny. And in order for the government to restrict a fundamental right, such as privacy, the government has to show that there's a compelling government interest and that the way they do it is in the least restrictive manner possible. And what this case does is he says, no, that standard no longer applies, and that which is the highest standard. Right? It's the highest standard. It's a very difficult burden for the government to reach. What Alito says is no, it is rational basis, which is the lowest. It's the easiest standard for the government to meet. And he says as long as it's not batshit crazy, that the government can regulate abortion, meaning the states. He says that he's returning it to the states. He says this is not the concern of the courts, that this is to be decided in the state legislatures, and that the state legislatures get to decide what women can do with their bodies and how to regulate abortion, and that any judicial review has to be done on a rational basis, which basically means that as long as the government can show it has some rational reason for wanting to do this, the court's not going to interfere with it. They can do basically whatever they want. Again, this is a very federalist society mentality. It is legal positivism. It is hardcore textualism. It is not the thinking that we have enjoyed in the at least the latter half of the 20th century. Alito spends a lot of time talking about the history. There's page after page of this thing. In fact, the last probably 30 pages of this decision are just citations to old statutes. And he's exploring the historical law about abortion. He goes back as far, I looked, there was one citation in there from a 1602 British case. What Alito misses, in my opinion, is the fact that these statutes and these laws and this history that he's looking at, which he says, in order for this right to exist, it has to be deeply rooted in the history and tradition, and in the history and traditions of the United States. And the problem is that I think Alito is missing is the fact that healthcare 100 years ago, 200 years ago, 75 years ago, isn't what it was today. If you went back to 1900, 99% of all births happened in the home, right? There wasn't a doctor present. There might have been a midwife, right? So in 1850, women did not have access to physicians. They could not go get abortions. They could not get health care in the way that they could in those historic times that Alito is saying should govern our behavior today, right? Alito, again, is living mentally in another century. And he thinks that's where he belongs, right? He has a sincere belief that he doesn't think about this as a modern man. He thinks about this as somebody who lived 200 years ago. And so he's looking at all this stuff that was going on 200 years ago. And what is missing in his analysis, and I think it's a big hole, is the change in society, right? Is the fact that birth and reproduction is much more medical than it's ever been, right? 99% of births today happen in hospitals with physicians and trained midwives attending. 100 years ago, if you wanted to be a physician, you didn't have to go to medical school, right? You just kind of hung out a shingle, right? We didn't have the healthcare that we have today. And so, to me, that is one of the big flaws in Alito's analysis is that he is comparing apples with oranges. But anyhow, he spends a lot of time, and I would say the majority of his analysis, either insulting the prior courts that sat before him. He's kind of like Scalia in that he's not very respectful to precedent or arguments that he doesn't agree with. And he's really, like I say, he's rooted in this idea that unless they were doing it in the 1790s and 1820 and 1850, all those times, that it's not what we should be doing today, and it's not. The law shouldn't care about that. If you want to change something from the 1820s, you got to go amend the Constitution. But there's no constitutionally protected right that has just emerged from the nation's experience. I think this is a flawed analysis, and I think if I were betting, a lot of people right now are speculating, where is this going? Right? What other rights are going to be impacted by this decision? And here's what I think is coming next. I think the next area is going to be birth control. And I think specifically, I think it's going to be access to birth control by people who are, say, under the age of 18 or 21. I think those are the easiest places for them to go next. I actually don't think it's going to be gay marriage. I don't think most people care that much about gay marriage. But for some reason, sexual reproduction issues get people all hot and bothered. It's a massive sea change in the private lives of Americans. Whatever the final form of this decision looks like, it's very clear that the court is going to strike down Roe v. Wade, and that women in the United States are going to have to fight for their reproductive rights. And many other issues are going to be on the table too. But this is a sea change. Speaking to the state of Florida, Florida has a privacy provision in our Constitution that courts have historically looked at as securing reproductive rights in the state of Florida. Whether or not our current Supreme Court will continue that tradition remains to be seen. I wouldn't count on it. However, Florida does offer us a glimmer of hope in that I think that it would be possible, with the right organizing and the right action, to actually put a right to abortion and to reproductive rights in our state constitution. Our constitution has actually been amended, the state constitution has been amended a number of times for all sorts of things, and I think it's possible that you could get that passed. The last thing I want to say is, it looks dark right now if you're a supporter of reproductive rights, but don't give up hope. It is usually darkest right before the daylight, and you now know what the deal is. You can now organize, you can now work to secure these rights. We can no longer count on the courts to protect our right. That obligation is now shifted back to us as the citizens. Whether or not you think that's good or bad, that's the reality. And this is the time to get involved. You can't sit on the sidelines. You've got to get involved. This can be changed, but only through hard work, dedication, use of the democratic process. I think while we're at it, we need to pass the Equal Rights Amendment. It's been too long. We're ready to do that. That should be part of the project here. And that is your Consumer Law Minute. I'm David Abrams.